Panel discussion number 3 will begin now. The topic of which is Digital Market Act DMA is inevitable. The discussion will start now and end at 1:30, and from 1:30 to 2:15 we will be having lunch. The moderator of this discussion is, please help me welcome, Mr. Shashank Gautam, Partner P&A Law Offices. Let's give him a warm welcome. And the panelists of the discussion are Mr. Ramji Srinivasan, Senior Advocate, Supreme Court of India. The applause continues as we welcome our panelists. Mr. Rakesh Bakshi, Head Legal Vice President and Associate General Counsel, Amazon India. Mr. Hitesh Mehra, GC Make My Trip. Mr. Sachin, Kalra, Vice President and Deputy General Counsel, HT Media Limited Group, and Ms. Neelambera, Sandeepan, Partner, Lakshmikumaran and Sridharan. Once again, a warm welcome to our panelists, and I request the moderator to please take over.
So I just got a message from Mr. Srinivasan. He's still in court. So as soon as he finishes, he will be here. So in the meantime, we can start. One of my running feud with the Gen Next seminar and Akriti is that don't give me graveyard shift after lunch or just before high tea. But I think this is a far more difficult session. 50 lawyers, hungry. 50 hungry lawyers in the lunch session. But I can tell you that this topic, though there is not much of attraction, not much being written and talked about, is indeed very important. Anything that you do in the digital space, whether as a business or an individual, your lives will be touched because of this legislation, even if it is in Europe right now, and a lot of other countries are considering it. Unless you are in Amazonian jungles, no pun intended. So with that, very good afternoon all of you. On your behalf, I also extend my welcome to the panelists. Before just starting on this panel discussion, I would just like to introduce the topic because as I said, there is not much being written right now in India, neither in the mainstream press or legal journals, so I'm just sort of feeling duty bound to explain what the Digital Market Act is. So the Digital Market Act is of a European origin. Many other jurisdictions are also considering bringing similar legislation. But as happens with a lot of competition law or data law related matters, Europe always takes a lead and sort of becomes a legislator for the entire world because it sets the tone for other legislations. They have come out with what is now called Digital Market Act. Actual discussion on it started somewhere in December of 2020, almost after 1.5 years of deliberation. As recent as 14 September 2022, European Council and European Parliament's President have given their consent, have signed it. It has become a law, but just like what we have here, even after presidential consent, it has to be notified in Gazette. I think that part is still outstanding. So this topic is as fresh as it can be, as I said, only 10 days back. Parallel to what was happening in Europe, there was also a movement in India. Last year, December, Standing Committee of Finance, which is headed by Jayant Sinha, they were interested with an investigation into anti-competitive practice by the large digital companies. They started their investigation in May of 2022, and what we have been given to understand that they have already submitted such a report in September, around September 7, 2022. So different from the topic, which is inevitable, we don't really know it is inevitable, but what we certainly know is government is considering bringing similar legislations in India. So that is why the relevance of this topic. We also understand from the report that, as in, it's more of a grapevine that Actual legislation, if it comes, will be several months away. Maybe something can be introduced in the budget session or the next summer session of the parliament, but no confirmed news in that. So just to understand, what is Digital Market Act? So Digital Market Act, the way it is divided is that it is only applicable for, firstly, a technology company. In that technology company also, it is applicable to companies which is qualified as a gatekeeper. Then the second qualifier is, even if they are a gatekeeper or a fairly large digital company, they should be providing certain core platform services. Digital Market Act provides clear threshold. They provide a clear quantitative threshold basis which a company can be identified as a gatekeeper. These are three buckets, just that it's easy to refer, which is the bucket of size, control, and durability or entrenchment of a company. Size is very simple in the sense that if the revenue of company is 7.5 billion euros, or if the fair market value or the market capitalization is around 75 billion euros, that is one quantification threshold. It may look a large number, but I can just tell you, for example, Zomato, though it is their GMV, they are doing business of around $2 billion in India right now. So maybe in a couple of years' time, they will already be closing to this threshold. So 7.5 billion may look high, but purely on GMV basis, it still will be quite low. The second factor is about the control of a core platform. That control is established by how many active users you have. Right now in Europe it is 45 million, which is around 4.5 crores of retail users, and if it is a business user, around 10,000. Again, for India it is just minuscule, because given the population and everything, it is nothing. 4.5 crore can be achieved by, say, a Zepto within a few months' time. The third part, which is the most important limb, and where this DMA has come is to regulate the affairs of the entrenched players or the durable players. So the entrenchment definition is again quantified in the sense that the factors that I have laid out in terms of market capitalization, fair market value, active user, that should be for at least 3 financial years. Only if it is there for 3 financial years, you will qualify as a digital gatekeeper. The consequences of being a gatekeeper is that there are certain clear do's and don'ts. For example, do's, interoperability, which is currently not there in many jurisdictions, it will become operational. Don't are like tying, bundling, parity, those kind of usual clauses that you see in the digital platform space, that will be prohibited for the gatekeeper companies. Penalty is huge. Any company which is found violating these, at the first instance under the Digital Market Act, the penalty is like 10% of their global turnover. So imagine that for Google, which is making $210 billion each year. Last year reported $210 billion, so the penalty amount could be $21 billion. At the second instance, it can go to 20%, which is $42 billion. So the penalty amount is quite high. And then, overall, right, as I said, it is a very new legislation. Not much has been analyzed, and commentators, I would say, is equally divided in 2 parts. One is saying that, okay, it is good because it brings contestability in market, it brings fairness in the market. You can't just be sitting on data, mining data, and that should not be become your tool or for maintaining your market position. You have to fairly share with others. But on the other hand, there is also a large body of scholars and commentators which is sort of questioning the motive of DMA, because DMA is somewhere impinging on innovation, a freshness which is brought in the market. For example, in the infrastructure sector, or generally in the economy also, you will say that, okay, a little bit of inflation is good because you are bringing more money in the market, you are putting more money in pockets of the consumer, so inflation is little good. So in that sense, competition law across the world, they sort of turn a blind eye, not I would say turn a blind eye, but they like to wait and watch as far as the digital sector is concerned, because innovation is one of the important cornerstone of choice or contestability or competition. Somewhere it feels like that because of the rule-based prescriptive thing, that innovation angle is disappearing. There are also some data points I'm just throwing so that I can catch hold of your attention. For example, if DMA is implemented in Europe, Apple Music, which only has a 15% market share, will be a digital gatekeeper, but not Spotify, which has 31% market share. Google Flight, which has been launched only 4 or 5 years back, will be a digital gatekeeper, but not Expedia. I'm pretty sure that all of us who have booked tickets, foreign travel and all, would have booked on Expedia, or at least would have checked on Expedia, but there may not be the same experience for Google Flight. Facebook will be gatekeeper, but not Twitter. So these kind of dichotomy, these kind of conflicts are there. Apart from that, again, it is far, far away. We don't even know what will be the shape and size of it in India. But if it is adopted in a similar situation in India, after adjusting for population or the growth in the country, there are also issues around the arbitrariness. Simply the way I was explaining to you that why only Facebook will be gatekeeper and not Twitter. The impact of both these companies will be more or less the same. There could also be trade restriction issues, because if you really see the market capitalization or fair market value or monthly active users, it will be pointing only to the US tech companies, and in Europe it is called techlash, as a backlash against US. That will be issue. There can also be issues around the IPRs. So these are the broad contours that I thought I'll just set it out, and with this, now I will introduce the panel here to discuss this point. And my first question will be to Mr. Bakshi. Sir, based on your own industry experience, and you have been also participating in this deliberation before the parliamentary committee, what is your view? Is India in the correct stage right now to have a Digital Market Act or ex-ante legislation currently?
Thanks, Shashank. I think a very comprehensive introduction to the topic. And I think some of the answers to your question are in the opening remarks that you have given. I think the point really is that it's an issue of a transplant, right, at the moment. So what is happening in Europe as under the Digital Markets Act is something that we are thinking or proposing to transplant. And transplants have their own problem, as you know, in medicine. And I think they are applicable to law as well. That sometimes the immune system can react very adversely to it. And the reasons for that, because the bodies are not the same. And I think drawing on that parallel, if you really see that the state of play in India today, as far as digital markets goes, is very different from the state of play, say, in Europe. And I think that DMA has been designed to address a different problem. And it has taken some deliberation, even in the EU, to get this law passed, almost 2.5 years of deliberation. And I think the complexity of the legislation and somewhat the vagueness of the legislation also has demanded that its implementation date is pushed out by another 2 years. And and what I understand also is that a lot of companies are going to be seeking clarifications on how to go about implementing it, and if they are covered under what part of it, and then what changes do they need to make. So I think there is a lot of clarity that is yet to emerge. So it's very early days for the DMA in Europe. We don't know how it will impact the markets over there. And to start thinking that this is almost the right thing to do for India, maybe a bit premature in my view. I think also taking that argument forward to just show what differences are there. If you look at it, for instance, e-commerce. E-commerce and the state of play in India is very different from what it is in Europe. E-commerce, for instance, in India, we cannot do retail online. It's allowed in Europe, for foreign companies, that is. And if you really see that we don't have a hybrid model, our marketplace We are a 3P marketplace, so there is no selling of products by Amazon. So a lot of the concerns that are there of gatekeepers, of issues where there could be a conflict of interest is not relevant to the Indian market, really, because Amazon will not be able to do retail as far as we go, and also other foreign companies go. So there is that difference. But then also you can move on further and see that the e-commerce penetration in India is very, very low at the moment. It's hardly in single digits today. It's much more advanced in Europe. So is it something that you want to start kind of doing in India as well at this very early stage of e-commerce? The third problem is the definition of digital markets itself. What is covered, what is not covered. And to the point that Shashank was making, that there are certain very conflicting situations that can arise. So there are definitional issues that will come into play that we need to be careful about as we go about absorbing what's happening in Europe and try to transplant that into an Indian context. And I think the other piece is that the issue that we face in e-commerce in India is not there in Europe. For instance, our challenges are more about expanding the use of e-commerce, making digital access available to a large section of society that is not being benefited by it. So if you really see that there is no issues of competition that are coming up at this stage in India. In fact, if you see the number of unicorns that have come up in India, the new Mishos of the world that are coming up, the Nikas of the world that are coming up, the disruption that is happening in the marketplace, 2-hour delivery, 10-minute delivery, and Blink, and so on and so forth. So I think if you really see, it's a very vibrant marketplace. It's pulsating at the moment. And to think that there are issues that need to be addressed in this space may be something that may be again very premature. There doesn't seem to be any barriers of entry. There doesn't seem to be any misuse of any kind of data that you may have with certain players and all of that. So I think those issues are not at play at the moment. So what really is needed is also a serious gap analysis to see that if you're introducing a new legislation, what is the reason why you want to introduce it? What are the gaps that you want to address? Is it a simple replication of what somebody else is doing and I want to do it? I don't think so. A similar gap analysis has been done as yet to see what should be in that proposed legislation that we need to address. So, cutting a long story short, I think maybe a bit premature in the journey of India in digital markets and specifically for e-commerce. That we need to take a harder look on how this will play out, because there are always unintended consequences of doing certain things. And if you start regulations much before the market is mature, you kind of stifle competition, you actually stifle growth, you have a chilling effect on innovation. And I think those are the things we need to keep an eye on.
Thank you, sir. With this, I'll pass the mic to Hitesh. Hitesh, you are sort of uniquely placed in the sense that Make My Trip is, perhaps for a lot of us, is the first, I would say, intermediary or a technology company where we have booked a ticket. So it is around for some time, just like IRCTC and all. What is your take on this entire Digital Market Act or ex-ante legislation? Because primarily you have functions in India where you are competing with large global companies like Booking and Expedia.
I think you've set the context very well, and Mr. Bakshi's supplemented that with very key concerns. India is one of the three foundries of global foundries of startup unicorns. Many of them are in the digital intermediation space, and intermediation involves fast, explosive growth. Without that, intermediation just whittles away. The model doesn't survive, and therefore, any threshold-based law, where the business essentially has to look, am I, exceeding the mean the examples that you gave of a virtually vertical demand fulfillment intermediaries who would get caught in this net, it's bound to have a chilling effect on innovation and therefore growth and capital flow. And we have to now compare this with the DMA White's caught flight in Europe. The French politics involved in it, Europe's general economic outlook, and what it's likely to happen in the next decade. Do we really want to follow that model? Do we really want to follow them economically and politically? Given where we currently are, India is at the cusp of explosive growth. Is this the time to do that? And the second thing is, we are behind the curve on many current robust and tried and tested regulations where we need better enforcement, better regulatory capabilities. We have the Competition Amendment Bill, which is, a very sensible piece of legislation which has been pending for a long time. The data privacy law, if we work on those components, and if nothing else, we just think about if the commitment and settlement framework was there in the competition regime, the business community, whether it is Indian or global, big or small, will always adjust to objective suggestions coming from the regulator and from policy makers, provided there is a framework for channelizing and pivoting models. But it shouldn't be the artificial thresholds which are being thought of through the area. The context is completely wrong for us. We've seen in India industries grow when there is no or light touch regulations. We need to stick to that success formula. Otherwise, I think we'll look back and with a sense of pride.
Thank you so much, Hitesh. And you have just set the right context on this, that on DMA, perhaps it's just not law, it was also a lot of politics there, led by Germans and French, and against what they have started calling GAFAM, which is Google, Amazon, Facebook, Microsoft, and Meta. So it's more or less the whole discussion. If you read the discussion text, in Europe also, it looks like somewhere they are trying to catch these companies, and it has become a transatlantic divide between European companies and American companies. And do we really need that? Especially in the sense that our own growth story is very different in terms of users, in terms of innovations and everything. We have currently 114, this is government's own data, unicorn, and these unicorn is not concentrated in any market segment. Across market segment, you pick a market segment, and you will find there are at least 5 or 6, and these numbers are going to grow. So from there, I'll just move to Sachin. I'm not cutting out Neelambera, but just that first, let us hear the industry view, and then we'll come. So Sachin, what is your view? Do we need DMA from your own industry experience? What do you have to say? So by DMA, I mean to say, do we have to have ex-ante legislation like DMA in India?
Thanks, Pushpa. You have set up the tone accordingly entirely about what DMA is. My personal take is not my company state, which I personally feel as the Digital Market Act, which is basically what it says about. It is this it's the cutting of unfair trade market between a supply chain built by the big tech companies, which are called to be gatekeeper in that particular population. What India will come up, no one knows right till now, which way it's going to materialize. But however, if you see there are two bodies, but it will be DMA also and a CCI also, they will contradictory views always together. Why two bodies required? That's a question which comes always in mind. Why? Since a market is already defined in CCA, and that could be further amended in CCI Act also to the level that it can be played. But since GN committee has always submitted its report and says that DMA is the next to which India also come up, which they're following the Europe, like GDPR, they're following the last couple of years, data privacy has not come to us. I don't personally feel that it's going to come up for a couple of years still, even if the report has been submitted. But however, I personally feel like CCI also has taken that view on Google side or a big tech side. Recently, they passed an order asked for investigation to VG, and primarily they've had that entire supply chain, which is there on part of where the advertisement builds up. This entire marketing is done through that only. So even an ad tech company or a company who's a bidding company in between, or a pragmatic app which has been placed on a mobile, each mobile has pragmatic app, then only you can see other apps also. There is a monopoly which is going on, an unfair trade practice which is going on from the big tech companies and the local companies, the small IT players which are there who would want to build up locally, they want to build up and grow. They are being curtailed because they are not getting a name or they are not getting a platform to work on the part. So as a company, an advertisement basically, I personally feel that's good law which is going to come to India, but it can be built in the CCI also, it can be done in current acts also and move around it. All acts provide that. Even IT Act has a provision on that part also. Like e-commerce companies are struggling today to get what is the e-commerce regulations. Again and again, something comes from the Consumer Protection Act, something comes from the CCI, something comes from IT Act. It's all completely on a struggle stage. So I don't see that what ministries or parliamentaries are looking into getting in multiple laws coming to just. Test of law still to be taken by the Supreme Court or by High Court, which is there, like IT rules which they framed recently, couple of years back. It's still struggling before the multiple benches and multiple courts to give clearance on that. So similarly, views, who's a gatekeeper, that's a basic thing, and gatekeeper is already defined basically what it says about. It says e-commerce companies there, which has a multiple threshold built into 3 types of categories which they have. E-commerce are there, big chat, social media companies are there, or even supply chain companies are there. These all will be part of that. As we know that how this is going to build up, definitely it's going to build up soon, but how much time it will take, it's going to be initial stage till now. For me as a company also, on our advertisement side, if you say, yes, if you curtail those loopholes, we'll be in a benefiting pictures also. And similarly, CCI is also working on that part now.
Thank you so much. And Neelambera, your view will be most helpful for the audience to understand why do you think, based on your own practical experience of representing companies before CCI or advising them, these tech companies, where do you think that government felt a need to have a discussion or even a thought on these lines that we need to have an ex-ante legislation? Because in terms of timeline, 2019, CLRC committee report had submitted its report. As in CLRC committee submitted its report, we know that more or less they were of the view that whatever we have right now is adequate. Then in January of 2020, e-commerce market study report came. It identified what are the risk items, and after that you are seeing a spate of investigation ordered against companies in each segment. In fact, last counted, out of like 114 unicorns, almost like 8 to 10 are already under investigation. And it's just not about US companies. There are far more number of Indian companies facing investigation right now. So where is that enforcement gap? Where is that thought coming for having this kind of ex-ante legislation?
Thank you, Shashank. So first of all, I think this is a great topic for discussion, given that it's so new, so fresh off the stove right now. It's good to start discussing these issues early on, so that when it comes times for representations, there is more thought as an industry, as a practitioner that we put to it, and those thoughts would be more constructive. So yes, I mean, like you correctly pointed out, there are a lot of these investigations going on in India right now. The Commission is very new to this sector, this Competition Commission. So over the last few years, let's say over the last 5 years, whether an investigation is even required in these markets, that has evolved. So starting, let's roll back in time, 2015, that was the first time when e-commerce companies were coming under investigation, under the radar of the CCI. And a lot of information were being filed. And the CCI was of the view that they haven't reached that market power where they need to be regulated under the Competition Act. They're market disruptors. They are new entrants. There are already very entrenched local offline players. And therefore the e-commerce or the digital market players are not in a position to tip the market. Fast forward 7 years, we're talking about whether the market has already been tipped. Now, these investigations only started to pick up pace somewhere around 2018, 2019, or some even 2020. So the time that the Competition Commission has had to evaluate this sector, the actions in these sectors, has been very short. Compared to the EU, where this has been going on for years, there have been judgments already, people have been penalized. And that is when they have realized that e-commerce, digital markets are at a point in time where maybe ex-ante regulation is required because ex-post regulation is not taking care of these issues. Now, coming to your question, Shashank, where have we felt the need? And very rightly said, the government has had this thought in mind that there is something going on in this sector which needs to be regulated from different forces, different angles. So the Competition Amendment Bill, which is a great step forward, which is going to take care of a lot of issues which have been felt globally. In India, we did not have the kind of authority to check those kind of conducts, those kind of M&A activities, and that is going to come in now. So in my view, I think we should let that come in first. Let's see how that takes care of a lot of issues. Instead of abandoning it or simultaneously having multiple legislations, or at least having the thought of having multiple legislations, which is only going to increase the onus on the companies, which is going to increase the compliance requirements, which is going to confuse the regulators themselves, because then a legislation is only as good as its enforcement. And with multiplicity of legislations, that enforcement is going to be a big challenge in India. Who is going to take the lead? A lot of this is going to go to the Supreme Court, where they're going to challenge the constitutionality of it, whether this is arbitrary, whether there is fairness involved or not. So, to my mind, I think we need to take a hard look into where we are as a regulatory jurisdiction in terms of competition law, in terms of data, in terms of IT rules, in terms of consumer protection. What tools we already have, and whether those can themselves be used to take care of the potential issues of gatekeepers that we are looking at. Because we're definitely not where the European market is or where the Americans are. So therefore, we first need to look inwards, see what tools are there, whether they can be used, because we've not really explored those tools as of now. So that's where I would stop.
So thank you so much. So just that brings us to like next part we can jump on. But just to share with you that when we had MRTP, the kind of rule-based prescriptive system which DMA is suggesting, and in fact a lot of authorities, for example UK authority, is saying that this may not be just the right model. They are deliberating their own model. Germans are also deliberating their own model. So MRTP Act until 1991, the size itself was, if you are reaching to a certain size, certain conduct was prohibited or regulated. So what we had sort of thought that we have packed up MRTP long back and we are moving into a new system. But the whole command and control prescriptive thing is coming back if it is there in ex ante. Because ex ante, let us understand that it will be sort of a per se rule. not rule of reason, which we are used to see in the Competition Act space. But having said that, and what Sachin has raised an issue that there is a section within industry that feels that, okay, we are not getting that fair chance to contest. Dice is loaded in favor of certain companies. Dice is loaded in favor of, say, MNCs, or dice is loaded in the favor of companies which has maybe multi-billion dollars of bank investment and all sort of things. So what to do? And this is a situation which government has to be impartially looking at, and they are perhaps, that is why they are thinking about such legislation. And assuming if there is a legislation, and that is part 2 of this discussion, what kind of safeguards as an industry you would like to have, what kind of discussions we should have, what kind of directions we need to take. Because this is the early stage, like September itself, committee has submitted some early indications of having this law. So if we start our discussion right now, of course we are able to provide some right concrete guidance to the legislators. So with this, Mr. Bakshi, what is your view if we are having this law? What could be safeguards which we can think of?
Thanks, Shashank. The safeguards, I think the first one really should be that we should wait and see what impact does the legislation have in Europe, and see how it plays out. Does it serve the purpose it's intended to? I think that is one clear thinking even before we jump into the legislation and safeguards that are needed. I think that much patience would be required to understand where this legislation is taking Europe. The second piece is that as you kind of think further, the question really is about gap analysis that I mentioned, that what you want to achieve. So once you start studying that, then you'll hit the right sectors and you'll hit the right note in terms of figuring out what you want to do with this and see how it will impact the Indian economy, players in India, and that gap analysis is going to be critical to understand what you want to fix. I mean, if it's not broken, let's not fix it has always been a maxim that has been out there. So if you really want to fix something, you need to understand what's broken. And flowing from that, really, as we discussed, is what players do you want to include in digital markets? And in that definition itself is going to be important. And the thresholds that are going to be identified once we get to that stage is going to be important to determine that you are hitting the right set of people, the right set of problems, and the right kind of resolutions that you want to bring about in the market. And I think, and lastly, as we take it a step further, we also have to play out the legislation from a policy perspective and see that really are you encouraging the things that you want to happen in that sector, or are you stifling it? And that is a very important aspect of legislation as they come into being. And I think that is going to be important to look at the unintended consequences of policies and laws that come into play. I think that is going to be important as another safeguard.
Thank you, sir. So with that, Hitesh, on the safeguard point, what do you think, what is your thought on that? And especially, I would like to understand from you the context of these numbers which is given in DMA, and assuming similar number comes in India, or at least they consider just doing a copy-paste. I would say a lot of unicorns here are already approaching that number or may breach in next year or two. In that situation, what do you really feel, what should be the safeguard? One is, of course, on the objective numbers that they are seeing, but otherwise, what kind of safeguard should be there if government considers bringing such legislation?
Yeah, in India, this is a more accentuated problem than in other legal jurisdictions, is because our regulators love false positives. They want to cover everyone. Once the law comes in, we'll have the cat among the pigeons. thresholds need monitoring, and our legislative environment and history hasn't hasn't had any instances in the past of how should a threshold-based legislative framework be regularly maintained. We've had so many redundant laws, and this would be something which will be misapplied and, like I said, create false positives and not meet the purpose. The intended purpose, the mischief is understood, needs to be addressed. It needs to be addressed with the current instruments we have, and that needs to be fixed. We don't have industry data in many of the digital markets. We need to fix that. We need to fix the resourcing in the the CCPA, the CCI, and its various units. That's the way of solving this. So also on the I guess all of us would echo that wait and watch is the correct approach, more so because we know how implementation guidelines start flowing from the EU, because there are already a lot of conflicts over there between the existing regulations. We'll also understand from these implementation guidelines also how the European Commission and the judiciary there is applying these thresholds to the identified market participants. That is very essential for the application of this law in India, even if it's just a cut paste. So, and assuming for one moment that we were to have this law in reality in India one fine day, then at least as a starter, we should adopt two core platform services threshold rather than one. At least that will give some breathing space and people and participants who are in core vertical demand markets don't need to look over their shoulders and what about thresholds. So they have to become reasonably big in size and responsible.
Thank you, Hitesh. You have raised a very good point where it is that a company which is vertical in the sense is active only in one core platform, whether they should be judged of the same standard compared to companies which are tentacular and present across different services. A very good point, Hitesh, there. And with that, we'll move to Sachin. Of course, Sachin, we heard your view, how it is tipped, or what I would say that for an Indian companies, it can become a little problematic in the current environment, the way the competition is, the way the ice is loaded. But once the legislation is there, it is applicable to everyone. And as I was explaining you, that there are a lot many Indian companies or Indian unicorns which is subject matter of investigation compared to also. So it will be applicable to all sort of companies. May not be in next 3 years, but definitely in next 5 years, there will be far more number of Indian companies which will be subjected to this legislation, if it is there and if the current thresholds are to be taken into consideration. Given that, what would be your take on what kind of safeguards should be there?
Right, Shashank. So, what I say that what safeguards should be there on a registration. One, see, European market is a developed market. We are a developing country basically, which we all say. And everyone is on a rishi stage to work on that and start working on that. Once we are developed, we are materialized, we are mature enough now, then this law seems to be very applicable and it will work around each and every one. So that's the one thing. Second, the market is big size. The geographical market, which the population-wise in India is the biggest market, I think, so for entire chat which is there, and everyone looks for Indian market only. The number of smartphones which are in India is now over all over the world basically. So what law is coming up is how it is coming and needs safeguarded basically for the structure that you need to see the geographical structure first of all, then accordingly push that list now whether it will be helpful for the customer or not. Basic purpose of any law is what the consumer should be benefited all around. So what is it consumer getting a benefit all around of that? That needs to be develop, not only develop, it should be read properly and then come up with the proposition that yes, this act is going to come in picture now. Whereas we said together on us, right, that CCI is already equipped with all those things. Let's wait for those amendments which is coming on or which are the flow, and then accordingly move around. Yes, this is a requirement in India today, or we can push it for a couple of years and then we come up with this law. Basically, that's it.
Thank you so much. So final words to Neelambera, to you. And my question to you is, are we going to be jobless? Because if it is rule-based, this is your size and these are the things that you are not going to do. Where is the question of bringing your legal submissions and everything before any court? Because, oh, look, you have 7.5 billion revenue and you are doing these 10 things. And what are competition lawyers or competition economists will be doing? So in some sense it is a competition law 2.0. What is it? And any safeguards that you would like to have, not just professional safeguard, but otherwise also?
Yes, that's definitely the first one, to safeguard the competition laws. So first of all, this cannot be a copy-paste, because what is there in the DMA cannot apply as is in India. It has to be customized for the geography, the economics of this country, the demographic of this country. So therefore it cannot be a copy-paste. It has to be a thought-through legislation which takes into consideration all of the facts that people have talked about today. The number of unicorns, the number of Indian companies which are at a stage where they may be tipping the market in their favor. So because we are not here to just oust the Americans or the European companies. So that is not what it is for India at all. The other thing definitely that there is that it is not going to replace competition law. It is going to be something that is going to work in tandem with competition law. And I say that because what is going to be covered under this ex-ante legislation is going to be something very specific. It's not going to be a sector-specific legislation. It is not going to be an enterprise-specific legislation. It will only cover very specific functionings or business aspects of certain enterprises. And therefore the competition law is still going to be there. There will be all the other aspects of competition agreements, abuse of dominance, because also, just taking a step back from there, gatekeeper is not a dominant entity. The definitions are completely separate. So it is not necessary that all dominant entities are going to be gatekeepers, even in the digital market space. So the competition law is going to be there. There is going to be multiplicity of regulatory aspects. The thing that worries me the most about ex-ante legislation is, like my co-panelists said, is the extent of monitoring that is going to be required. Because somebody who's a gatekeeper today may not be a gatekeeper tomorrow. And given the way these markets work, disruptors and all of that considered, every few years there's going to be a new gatekeeper in certain aspects of that. And therefore, the obligations, the reporting, all of that will need to be constantly monitored, constantly taken into consideration by the enterprises as well as the regulatory body. So this is going to be a space, if it comes in, where you would need a dedicated team of 100 to 100 professionals from the regulator's side who will only be monitoring this, whether somebody has become a gatekeeper, whether they have fulfilled their obligations or not, to what extent they are implementing the obligations that they have been inundated with under the legislation. So that is going to be a challenge in itself. So before we really jump into this, the entire framework has to be thought through. And without that, this is going to be, as Hitesh loves to say, a false positive for a lot of people. And it's going to just create more regulatory hurdles, more challenges for the legislation to be implemented. And ultimately, it won't serve the so-called purpose that it is supposed to serve.
So thank you so much, and that brings us to this session. Thank you so much, panelists. And it's heartening, Neelambera, that not just competition, but we'll have another law also to practice. Looks like good for business. So thank you so much, and I hope this topic sounded at least as interesting to you as we thought, and personally we are, as I started, that this is going to be going to touch your life in some way. Whether you are a business, whether you are a consumer, this law is definitely going to have an impact if it is brought to an end. So thank you so much, panelists. Thank you so much, audience. Thank you, Legal Era, for giving us this opportunity.
Indeed, yet another fruitful discussion. Thank you very much, respected panelists, for adding so much value. Ladies and gentlemen, now we lovingly invite you